That's not right, though. You can't just go in and out of people's checks. Don't send them nothing. Don't tell them nothing. Got me all messed up. Got my bank account messed up. Messed up my Christmas. Messed up Thanksgiving. Messed up everything. And
all right, buckle up, because this case isn't your average small claim spat. We've got a trucking school chasing down $750, a defendant who insists the whole thing is unfair, and a courtroom dance over something called garnishment, when money is pulled directly from your paycheck to settle a debt. On one side, attorney Ashley Hartman is pushing for a settlement and a legal stipulation to stop the paycheck deductions. On the other, Charlie Buchanan is frustrated, saying his holidays were ruined and his bank account was wrecked. But here's the twist. Charlie says he'll pay, but he won't agree to the terms the attorney's setting. And that's where Judge steps in, warning Charlie that without agreement, he's likely to lose. This is where law, frustration, and holiday drama collide. And trust me, you'll want to see how this plays out.
We call the matter of suburban truck driver training versus Charlie Buchanan, case number 17C0641.
Thank you, Judge. Again, for the record, attorney Ashley, known as Hartman, for plaintiff.
Please state your name again. I'm sorry?
Charlie Buchanan.
Thank you. All right, where are we?
Judge, even though based off the defendant's behavior, I think we have an agreement that he's going to pay the $750 within 30 days. So as I was trying to advise him is that I wouldn't mind to do a stipulation to suspend the garnishment from now till obviously the 30 days. So that way there won't be any further withholdings from the garnishment and he can pay that $750 on or before February 2nd would be about 30 days.
Oh,
to make it to streamline the process, Judge, I would ask for permission to sign his name so I can get the stipulation to you, so you can sign it, so he can get it to his employer, so he won't have hopefully another withholding by his next paycheck.
Can I say something?
One moment, please. He filed the objections. I guess they're still withholding and waiting on my order as to what to do with those withholding.
So yes and no, Judge, because we just got a withholding on 12/13. So I can't remember off the top of my head when the last hearing was because I didn't appear for it. My colleague did. But the last withholding we received was 12/13.
12/12.
Okay, so that was probably obviously before the objection may have been filed. So you're right.
It was after. They're supposed to stop withholding.
Well, it was received by us on the 13th. So
I
probably.
see. Okay.
Right.
I got it.
So if that's the case and they're just waiting for your order, then we should be good. So I would agree to suspend the garnishment for the 30-day period to allow him to pay the settlement. And then once obviously the settlement is paid, we would file the release and satisfaction.
Mr. Buchanan, what would you like to say, sir?
This is a key turning point. Charlie is saying he'll pay the $750, but he refuses to agree to the lawyer's exact terms. Here's the problem. In legal terms, paying without a formal stipulation means the garnishment might keep hitting his paycheck until the paperwork says otherwise. And that's the attorney's whole point. They're trying to lock in that stop order so Charlie doesn't lose more money than necessary. But by resisting, Charlie is actually putting himself at risk of paying more than $750 in the long run. The real question here is Charlie refusing out of principle, or because he doesn't fully understand how these legal steps protect him? What do you think? Stubbornness, confusion, or both?
I really don't have nothing to say. I just want to get done with this. I don't feel like this is fair. So I'm just going to pay the $750. I thought coming to court, we could.
Mr. Buchanan, I don't have the authority to erase a debt that you clearly still owe, whether they just didn't do it for 3 years or how many years.
That's not right, though. You can't just go in and out of people's checks. Don't send them nothing. Don't tell them nothing. Got me all messed up. Got my bank account messed up my Christmas, messed up Thanksgiving, messed up everything. And I just want to leave. I'll pay the $750. That's all. It's ridiculous.
The way so, sir, what she's telling you is that in order for this agreement to be in place and for your checks to no longer be garnished, you have to agree to stipulate to that piece Are you doing that too, or are you not?
Paying the seven, I don't agree to nothing she said, but I'll pay the $750 to get through.
Well, Judge, if he's not agreeing to what I said, we would just ask that the garnishment be
Because
denied based on the law, and we continue on with
It's not fair. It's not fair. It's not fair. And I told you I'll pay the $750, but do what you do.
You're either reaching an agreement, sir, or you're not. It's not.
I said I'll pay the money. I don't know.
Buchanan, you need to stop speaking over me, please. So I need you to fully understand. You're either reaching an agreement, or I have to make a ruling on your motion that's before me. And so if I make a ruling on your motion that's before me based on what they've said.
Right here, this is where the stakes get crystal clear. The judge is spelling it out. Without agreement, she'll have to rule on the motion in front of her, and Charlie will lose. This is the courtroom equivalent of a red flashing warning light. You can see the tug of war. Charlie doesn't like the system, but he also doesn't want more money disappearing from his paycheck. It's a classic clash between frustration and procedure. And if you've ever wondered why judges sound so firm, this is exactly why. It's to push both sides toward a resolution before the clock runs out. Would you take the deal here, or roll the dice and let the judge decide?
And your general objection, you will lose. So they're telling you that if you're going to pay the $750, there's a stipulation that has to be put in place for them to stop taking money out of your account. Do you want to do that or not?
Yes, I do. But you told me they weren't allowed to go back in my check.
No, that's not what I was saying, sir. They're not supposed to be doing that once the objection is filed. But then they are still his employer, correct? The employer. But the employer is still doing it. So she wants to get them in order to make sure that they stop. That's what she's trying to prepare for you in order to ensure it doesn't happen again. Now, whether you want to do that or not, I'm not giving you legal advice. I can't do that. And I can only tell you what the order is that she's trying to get to you. And Miss Hartman, given his posture, I'm not comfortable with telling him that you can sign his name. I think you should send that to him so he can look at it and read it for himself.
Sure.
So I don't know if you guys exchanged email.
I just want, she can sign it. I agree to everything. I just want to pay the money and be done with it. That's all I want to do.
Okay. All right. He's giving you permission to sign it. And you'll be sending that over today, Ms. Melnis Hartman. All right.
Yeah.
Thank you.
Thanks, Judge. Have a good day.
Thank you. You're all set.
And just like that, it's over. Charlie gives in, allows the attorney to sign on his behalf, and the stipulation moves forward to stop the garnishment. Legally speaking, this was a smart move. It prevents any extra withholdings and closes the matter cleanly. Emotionally, you could see the frustration boiling the whole way through. This case is a perfect reminder that in court, understanding the process is just as important as fighting for your side. If you found this case as surprising as we did, hit that like button, share your thoughts in the comments. Would you have taken the deal sooner? And don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got plenty more coming your way.